This is Thomas Jefferson, the author of the Declaration of Independence. But those words up there behind him aren't the Declaration. They're the names of the 600 slaves on his plantation. There's a tension, obviously, between the words of the Declaration and the practice of slavery. Jefferson never resolved that tension in his own life. He owned slaves until he died, and freed only a few of them in his will. The Founders' Constitution didn't resolve that tension either. The preamble talks about the blessings of liberty, but several provisions of the original Constitution protected slavery. In this module, we're going to talk about that tension and how it was ultimately resolved in the Civil War. The Civil War, I'm going to suggest, was in many ways the death of the Founders' Constitution and the birth of a new America. And now we come to the Second Amendment. This is one of the really controversial ones, the hot-button issues. The Second Amendment has defenders and critics who are as ardent as any you can find. And when you make a list of successful constitutional movements, the National Rifle Association has to be right up there. Does that surprise you, that I call the NRA a constitutional movement? It shouldn't. That's what it is, just as much as the NAACP, or the feminist movement, or the movement for marriage equality. And we'll see, in fact, that the NRA strategy of constitutional advocacy resembles that of the NAACP in some ways. The point I want to make right now, though, is that there are constitutional movements of all different kinds. There are traditionally liberal ones, like the NAACP and the feminist movement. There are ones that straddle ideological lines. Sometimes free speech advocates are on the political left, and sometimes, campaign finance reform is an example here, they tend more to the political right. And there are ones that tend consistently to the right, movements for property rights, for instance, or economic liberty, or the Second Amendment. Now, I don't like to talk about left-right politics that much when I talk about constitutional law, because there's already enough danger of people thinking that constitutional law is just politics by other means. In a very important sense, it's not. If you could get inside the mind of a Supreme Court justice deciding a constitutional case, you would see that they do not experience that decision as a political choice. Constitutional law professors don't either. They experience it, instead, as a process of trying to understand what the Constitution means. All the same, it is true that people's constitutional views tend to align with their political preferences. I can't deny that. But I want to suggest that this is not an indication that politics is corrupting constitutional interpretation. What it means, instead, is that there's a connection between constitutional law and political or social movements. The Constitution contains a lot of provisions that are relatively vague, that the Supreme Court has interpreted to embody relatively general standards. The government has to be fair, for instance, under the Due Process Clause. It can't treat people differently without adequate justification, under the Equal Protection Clause. And the Constitution doesn't tell you what's fair, or what's an adequate justification. That's a question that we have to work out on our own. And we do that through social and political movements, because those shape people's views of the world. So American political movements frequently make their claims in the language of the Constitution. And when they succeed, the Supreme Court frequently ratifies their achievements in opinions that endorse their views of the Constitution. That's what happened with race equality, with sex equality, and now with sexual orientation. People argued that certain kinds of discrimination were wrong. And eventually the Supreme Court said, yes, we think they're wrong too. We think they're unconstitutional. And this is what happens with the right to keep and bear arms. What this means about the Constitution, the general point, is that the Constitution is not really a document that magically has all the answers to all the hard questions society faces. It would be crazy to expect that. What it is, instead, is a framework within which we can make arguments about what the right answers are, about what fairness and equality require. These look like political arguments or moral arguments, but in fact they're constitutional. And now, let's take a look at how that process is playing out with the right to bear arms. The great debate over the Second Amendment, which the Supreme Court has recently resolved in part, has been about whether it protects an individual right or a collective right. Is it a right that individuals can invoke, or does it rest with states and their militias? Let's start at the beginning, with the amendment itself. The Second Amendment is unusual in that it tells you why it's there. It tells you what it's supposed to do. We have the Second Amendment because a well-regulated militia is necessary to the security of a free state. That's why the right to keep and bear arms shall not be infringed. So this tells us what the amendment is supposed to achieve as far as federal laws are concerned. It's supposed to preserve the viability of the state militias for several reasons, but perhaps chief among them, so that the state militias can stand up, if it's necessary, and fight off the federal government. That means there is a collective purpose here. The point of the amendment is to protect state autonomy, not to help out hunters, and not even to facilitate private self-defense. But knowing the purpose doesn't actually tell us the scope of the right. It doesn't tell us whether it should be limited to arms bearing that's related to state militia service, or whether it extends beyond that. Because it's quite possible that the framers had a collective purpose in mind, but chose to promote that purpose by protecting an individual right. And indeed, this is more or less what the Supreme Court ended up saying in a bitterly contested 5-4 decision when it struck down the District of Columbia's ban in the Heller case. Heller is an example of strategic constitutional litigation, just as much as Brown v. Board of Education was. The lawyers who brought this case wanted the Supreme Court to endorse an individual rights perspective, but they still chose a plaintiff who was a member of something like a militia, a member of the D.C. police force. Dick Heller was a special officer who carried a handgun as part of his job. He wanted to keep one at home for self-defense, but D.C. wouldn't let him. And the Supreme Court said, in essence, yes, there is an individual right here. It's subject to some regulations, whose permissible scope we won't attempt to determine now, but it is an individual right related to self-defense. That's D.C. But the laws that govern D.C., the laws that disarmed Mr. Heller, are federal laws, so he could invoke the Second Amendment itself. The second Supreme Court case, McDonald against City of Chicago, featured state authority instead. And now we aren't talking about the Second Amendment anymore. We're talking about the 14th, and asking whether it incorporates the Second Amendment, whether it allows people to assert that right against the states, like they can assert their rights to free speech or jury trials. There's a reason this might be a difficult argument to make. The 14th Amendment, we've seen, is a Reconstruction Amendment. It's about placing new limits on the states and giving new rights to individuals. So if you have a Bill of Rights provision that's about individual rights, it's relatively easy to see how and why that should apply against the states. The federal government shouldn't be able to censor speech, the founders thought. And the states shouldn't either, the Reconstruction Congress thought. So now you have free speech rights against the states too. But what about the right to bear arms? The point of the Second Amendment, I've said, is to protect state militias against federal interference. So can the Reconstruction Congress now be trying to protect state militias against state interference? That doesn't make much sense. And, perhaps more important, would they want to protect state militias at all? The framers love state militias. They think of the Minutemen, fighting for liberty against the British Redcoats. But when the Reconstruction Congress thinks of state militias, they think of the Confederates, fighting for slavery against the United States. In the war for liberty, the state militias are on our side. In the war for equality, they aren't. And yet, if you look at the debates of the Reconstruction Congress, you'll see they did in fact talk about the right to bear arms. They did in fact want to make this a right that individuals could assert against states. How can that be? The answer is that if the Reconstruction Congress actually wrote out the right they intended to give people against the states, it wouldn't have any introductory clause about state militias. It would just be an individual right to self-defense. The Reconstruction Congress isn't worried about the Redcoats anymore. It's worried about the Night Riders. It's worried about the Klan. It's worried that state police forces won't protect the freed slaves from private violence, that states might in fact attempt to disarm them to prevent self-defense. The National Rifle Association, interestingly, is formed after the Civil War by two generals from the Union Army. The Supreme Court pointed to this history in McDonald against City of Chicago, and it held that the right to keep and bear arms could be asserted against the states as well. So what it said is that you have an individual right against the federal government, which was given for basically a collective purpose, and the same individual right against the states, but this time for more of an individual purpose. The right is not absolute. Like all rights, it's subject to some kinds of limits and regulation. The Supreme Court hasn't figured out all the details yet. And for those of you who care about this right, on either side, that means there's still important work to be done.